Okay. Now, with that said, I want to now turn it over to our wonderful host. She's always smiling. When I'm in a bad mood, I think of Maureen and that smile. It gets me in a better mood. This is Maureen Reyes from ACAM Management Services. Maureen, take it away, my friend.
Thank you very much, Jeff. I am very excited to join forces here with Peter and you, of course. I see a lot of our clients, our teammates, our colleagues here, and also new board members I see as well. So I'm very excited to host and co-host with Peter. A little bit about Maureen, if you haven't met me before. I've been in the business for close to 20 years, currently serving in ACAM as a VP of Business Development. Been with ACAM for the past close to 8 years. And we actually are very focused on the Tri-County area. So Miami-Dade, Broward, and Palm Beach. Our clients are there. We serve over 16,000 homes, condo and HOAs again. And I'm here to always be of service, a resource to you, to your fellow board members, your managers, assistant property managers, whomever. I love this industry. I've been in it, like I said, close to 20 years, and ACAM has been in business for over 40 years. So, um, anything you need from me, I am always a phone call away. You could email me after the class if you have any additional questions. More than happy to provide. So, without further notice, I think that's in a nutshell. I am more than happy to be here, and thank you very much, Jeff and Peter.
Thank you. And
Thank
Peter?
you. Thank you. Are you going to start the slides? You want me to talk about me first?
A little of, I'll start the slides while you talk about you.
Right.
And by the way, we're privileged today, folks, because there aren't that many board certified specialists in condo and plan development law in the state of Florida. Peter is one of them. Take it away, my friend.
Right. Good morning, everybody. Thanks, Maureen, and thank you, Jeff. Yeah, my name is Peter Mullengarden. I am with K. Bender Rembaum. I am in the Palm Beach Gardens office. As Jeff mentioned, I am a Florida Bar board certified condominium plan unit law specialist, big long title. Maureen's been doing this 20 years. Lucky me, I've been doing this 42 years. So ever since I actually got out of school in 1984, I've been in the community association law business, either representing associations for about 6-7 years. I represent developers drafting condominium and HOA documents. But for most of my career, I've been representing associations in South Florida. Mostly Palm Beach, Broward, Dade, but these days, since I'm in the Palm Beach Gardens office, I would say it's primarily Palm Beach County, northward, up into St. Lucie and those areas. So anyway, enough about me, old guy. Today's topic is funding construction projects, which is something that, fortunately or unfortunately, depending how you look at it, all of you are going to have to probably do at one point or another. Examples of these projects up on your screen, as you see now, again, they run the gamut, but there's emergency mitigation. Sometimes that's post-hurricane or post-storm. We have code compliance with 40-year recertifications down in Broward and in Dade. Now we have the milestone requirements, as I'm sure most of you are aware. It's in the post-Champlain Towers collapse, unfortunately. So the milestone brought in a lot of repair, restoration work. Concrete restoration, again, linked to milestone in a sense, but that's been around, God, forever. And probably in my experience, concrete restoration, in my experience, probably the most expensive, the longest, the dirtiest, the messiest work you're going to be involved with. There's fire and life safety code upgrades. There's typical things wear out. So roof replacement, pavement replacement, all these are what I would call large cap or large projects. And that's probably what we're going to be talking about mostly today, as opposed to your day-to-day maintenance and repair. And next, different ways to fund these projects. Annual budget, although annual budget typically, again, especially because it's operating in reserve, today we're going to be talking more about, again, these projects that are not recurring expenses. These are projects that you're going to do once every X amount of years, whether that's a roof replacement, a concrete job, those kind of things. So the annual budget, it's possible it'll fund those big projects, but typically not, because typically they're going to be coming out of either the reserve part of the budget or through special assessments or loans. We're going to talk about that. And the one thing I want to mention here is pause for a moment, because this has come up for me recently and it's come out throughout my career. When you have these big projects, you invariably, or not invariably, but frequently, owners will say, hey, this project is too expensive, or we don't think that this engineer that you're using knows what he or she is talking about, and we think you can do it cheaper and do it da 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 da. And I want to mention that because you are going to get pushback sometimes from owners because, this is money, and typically that's what, you get pushback on more often than not. But there's something called the business judgment or the business judgment rule. I just want to remind you that if you're using an engineer in particular and you're going by the engineer specifications and you've made a reasonable business decision that, the roof needs to be replaced, the concrete needs to be done, the courts will uphold that. Unless you're acting in bad faith, the fact that certain owners saying it's not necessary, it's not needed, it's too expensive, or we don't think that the balconies need to be replaced, they only need to be patched. Those are board decisions. And as long as you're acting reasonably and you're following the guidelines of your engineer, notwithstanding that certain owners may jump up and down and scream and yell and say they're going to sue you because they don't want to spend that kind of money, if you're acting reasonably, a court will not substitute its judgment for your judgment in operating the building. So I wanted to stop and mention that because even though that's not quote funding, it is related. So I just want to mention that you can use your reasonable business judgment, and courts will not substitute their judgment for your judgment unless you're really out of left field. So special assessments, reserves, and borrowing, typically the ways you're paying for these projects. All right. So what about reserves? And we're going to talk about condominiums, co-ops, and HOAs. I know Jeff mentioned this is an HOA course credit, although a lot of this, quite frankly, has condo relations to it, especially this reserve slide. For condominiums, for those that have buildings that are 3 stories or more in height, for any building that's 3 stories or more in height, you have to have prepared something known as a structural integrity reserve study, or the CEUs is the abbreviation for that. If we're in existence before July 1st of 2022, and all this, by the way, was an outgrowth of, again, that Champlain Towers collapse, the CEUs, the milestones, those kind of things came out of that collapse. So if you're an association and you're existing before July 1st of 2022, and you're owner operated, you must have the CEUs, the Structural Integrity Reserve Study, completed by December 31st of 24 for every building, again, in the community, in the association, which is 3 or more stories in height. And then every 10 years thereafter, that study has to be done again, has to be updated. You also have what I would call, or what we call non-CEUs. Okay, those are those that are not in the Structural Integrity Reserve Study. And what are the CEUs items? Well, without going by memory, there's like roof, plumbing, electrical, structural components, painting, windows and doors, if they're maintained by the association, and anything else that costs more than $25,000 that the specialist who does the study believes has an impact on those other items. But you also have non-CEUs items, and the non-CEUs items can be anything from paving, anything that costs more than $25,000 to repair or to replace on a deferred basis is a statutory non-CEUs reserve. So that could be all sorts of things like elevators, cooling towers, that list goes on, that $25,000 threshold. So you have 2 components to your reserves. Typically, you'll have the CEUs, again, for 3 stories or more. If you're under 3 stories, you're not going to have CEUs. And then you have the non-CEUs items. How do you calculate the reserves? By the way, reserves are done based on the estimated deferred maintenance, repair, or replacement of the component over time, and then how much do you have to allocate, every year for the life of that item to reach that cost. There's 2 different ways to, I guess, maintain reserves. There's the straight line reserves and there's pooled reserves. And there's an error on this slide, and I'm going to mention that in a second. Okay. So when you have a straight line reserve, that means for every component has its own reserve account And so there'd be a separate reserve account for the roof, a separate reserve account for the plumbing, or the electrical, if now we're talking about CEUs. And then non-CEUs, a separate account, let's say, for the paving. Now, pooling versus non-pooling, in a pooled reserve, all the items are in a single account. You still have to maintain the separate calculation as far as estimated cost, estimated useful life, and to get the amount. But anything in that pooled items, the roof, the plumbing, the electrical, if they're all together, any of that money can be used for any of those items in a pool. In a straight line, you can only use the money that's in that account for that item. So the roof money only used for the roof, the plumbing only for the plumbing. You can create now through a board vote. That's where the slide is incorrect. It used to take a majority of the voting interest of the owners to combine reserves into a pool. The statute was recently amended, Chapter 718 was recently amended to say that the board can now create pooled accounts. There is a caveat though, okay? You cannot pool CEUs and non-CEUs, okay? So if you're going to do it by pool, the CEUs items are in a separate pool, and the non-CEUs items, the non-structural integrity reserve items, are in a different pool, and the two cannot be mixed, cannot be mushed together. Quite frankly, you have more flexibility as a board with a pool, okay? I'm not saying that the pool is necessarily better in one sense or another. I know reserve specialists, they like the pool because under a pool, you can actually allocate less money every year and still get to the same end result because the money is being used for any of those components, but you have to be accurate with your items. In a line item, you can't do that. So how about waiving or partial funding? Prior to the collapse and prior to the CEUs, you could vote to waive or partial fund any reserve account by a certain vote. Now, though, however, associations that have CEUs reserves, any budget adopted on or after December 31st, 24, which is past, okay, so any current budgets, you cannot waive or partial fund the CEUs reserves. So those structural integrity reserve items, those cannot be waived or partially funded by a vote of the members. On the non-CEUs side, okay, like a paving reserve, let's say, for example, the voters can vote if the board wants them to. Again, it's usually a board decision whether or not to even open it up for waiver or for partial funding. It's not automatic, but the vote has been increased. It used to be for a million years, it was a vote of a majority of a quorum at a meeting could waive or partial fund a reserve account. Now it's a majority of all the voting interests that are in the association. It's a key distinction because potentially a vote of a majority of a quorum, quite frankly, is a lesser vote often, but now it's a majority of all. But like I said, if a board wants to have reserves, doesn't want to present it for waiver on the non-CEUs side, they don't have to. Similarly, alternate use of reserve funds. Reserve funds are restricted. They're restricted accounts by nature, meaning they can only be used for that purpose. Now, the CEUs funding, that we mentioned a few times already, again, for any budget adopted on or after December 31st of 24, you can no longer vote to use those funds for something else. So in other words, so you can't have the owners vote to say to use some CEUs fund items for another purpose. It's locked in. On a non-CEUs reserve, you can still vote through the owners to use the reserve for something else. So for example, you have a paving reserve and you want to use some of that money for some other purpose, you have to get a vote of the owners. And now, similar to the waiver vote, it's now a majority of all the voting interests. That used to be a majority of a quorum, similar to the waiver or the partial funding. But both of those votes have been boosted. But I just want to remind you, I know I already mentioned it, but it's important. You cannot vote to waive, partial fund, or use CEUs money for other purposes. Those funds are locked in.
And Peter, I think here important just to mention, right? We've been in the business, far long. There's a lot of board members that had to get adjusted to all these new legal updates. It's been a year, 2 and 3. Most important, I think right now, the industry as a whole needs to understand that you need to work side by side with their management team and your legal counsel. Doing these notices It's not like, oh, copy and paste from last year. No, you have to make sure the notices are done correctly. So even the minutes capturing are important when you're looking at how you're going to allocate the CEUs or non-CEUs and funding, etc. So I think here critical, again, the takeaway value, Peter, of that important slide is work with your association legal counsel, especially for your notice and your minutes, because you don't want to, go through all that expense and then suddenly, you miss an update. You did something wrong, right?
That's an excellent point. It has definitely become, as you and I both know, much more complicated.
Yes.
Especially, I'm going to say it 100 times today, probably in the post-Champlain world, it has just gotten much more complicated. I'm not saying it's gotten better, worse. I'll say it's more complicated than
Yep.
it used to be. I also want to mention, because I guess I was bad on me. I will mention HOAs here for a second and their reserves. It's 1,000% different than it is for condos and co-ops. For a homeowner association, really don't have the restricted locked-in reserve accounts unless it's a reserve account that the owners have approved and the owners have voted in. For most part, in an HOA with a board-created reserve account, they're not restricted in the sense of the HOA board. Now, unless your documents say that, I'll with a caveat. If your documents do have specific provisions in there about the reserves in a homeowner association, then you have to follow that. It's a little unusual, but it's possible. So always check that out. But in an HOA, unless the owners have voted by a majority to create reserves, if their board created reserves, you're very flexible. You can move those monies around. You can use them theoretically for, or really for other purposes. So check with your counsel, because it's very, very different with a homeowner association as opposed to a condominium. Condominium co-ops, as I mentioned in the other slide, very restrictive. Okay, special assessments. Extremely important because, with these big projects, more often than not, you are going to be involved with a special assessment. Okay. What's a special assessment? Basically, a special assessment is just when you're assessing the owners for an amount that's outside of or in addition to the regular budgeted assessments. And the term special assessment's been around forever. That's what makes them so special. Well, special again, because it's not part of the annual operating or the annual reserve budget. Okay, so what happens with a special assessment? Okay, very important, and this is both for HOAs, condos, and co-ops. If you're going to be adopting a special assessment, the notice of the board meeting at which you're going to be doing this, it must contain the estimated amount and the purpose or purposes of the special assessment. Extremely important, by the way, that you do this correctly. Especially when we get down to the loans and things like that. But even for collection purposes, I know in my firm, if you haven't dotted your I's and crossed your T's, and talk about, Maureen mentioned checking with counsel, and you haven't done this right, we're going to make you do it over again before we start collections, because if we don't have the backup on how you did your special assessment, it's a problem. So what do you have to do? Okay. In the meeting notice, has to have the amount and the purposes. That notice, okay, unlike other meeting notices, this is a particular requirement for a special assessment meeting. It's a 14-day notice minimum, okay, which is sent to all the owners, either by mail delivery or electronic transmission. And by the way, pause here, your owners have to agree to receive notices by electronic transmission. If they haven't agreed, then you have to send it to them the old-fashioned way, all right? And I don't care whether you send out electronic notice to everybody just because that's what you do, all right? Because some associations just do it. Unless the owner has a specific written consent to do it when you're doing a special assessment, do it the old-fashioned way. If they've agreed to receive by email or by facsimile, for those people who still have fax machines, you can do it that way. Okay, so it's a 14-day notice sent to all the owners and posted conspicuously on the property. You got to do both. You have to send it to them and you have to post it. It's not an either or. It's a together. It's an and. You have to do it together. And the person who is sending out that notice and posting that notice on behalf of the association, he or she must sign an affidavit that the 14-day notice requirements were met or were complied with. Again, very important when we're doing collections, we want to see the meeting notice, we want to see the affidavit that it was sent and posted timely. Now, sometimes the affidavit is signed by the secretary. Sometimes it might be signed by the manager, depending on who is doing the posting and the sending of the notice. Now, in some documents, and this is this next limitation or bullet point, some documents will say you need owner approval for a special assessment. Now, you may want to talk to your counsel. In our firm, though, our position is if what you're doing is a necessary maintenance, repair, replacement project, then based upon case law that deals with actually alterations, but I'll mention why it's an alteration type case. There's a line of cases that basically says that if you're doing something that is necessary in the board's reasonable judgment for the repair, maintenance, or protection of the property or the residents of the property, then it's a board decision because the board is obligated to maintain the property and therefore owner approval is not required. Now, in these cases, they were material alteration cases, but we think they're applicable to the special assessment context. Two of the more famous cases is two beachfront condominiums had bad erosion problems. One extended a seawall. The other one built a rock jetty out into the ocean. Both were material alterations. And normally for material alterations, you need a certain vote of the owners. But in this case, the court held, since these things were necessary to protect the buildings from falling into the ocean, that the board can then adopt those, make that change or make that improvement because it was protecting the building. So we use those case analogies. One is Tiffany Point, one is Ralph versus Envoy Point, but we use those cases in the special assessment context. And we don't mean a special assessment, by the way, to build a statue of whoever, okay? Or you love the World Cup and you're going to build a giant statue of your favorite, football player. This is based upon need. So if you have a set of documents, and many have it, okay, that says you need X amount of approval of the owners for a special assessment. In our opinion, you don't if it's for a maintenance, repair, replacement, restoration project or other project related to the preservation, protection of the property or the residents. Okay. Board adopts a special assessment. You jump through those hoops as far as the 14-day notice and things like that. The board will also typically then establish the payment terms of that. That should be part of your board meeting, your minutes, when you adopt the special assessment, whether it's going to be a single lump sum, paid in installments, but also check your bylaws and check your declaration to see if they have any specific requirements for payment of assessments as far as notice requirement, things like that to your owners, because that obviously comes into play. I'm not shilling for lawyers here today. I mean, that's the last thing I want to do. People think that we're a bunch of bums and all we do is bill, and that's not necessarily true. It's not really true at all. But like Maureen said, when we started this does get complicated. You need to make sure it's right. It's worth, what's that, the whole thing, pound to cure, penny wise, pound foolish, just get it right the first time or try to get it right the first time. And, typically it's worth the relatively small investment. You got to realize these projects, especially concrete projects, in my experience, they're not all seven figures, but most of them tend to be seven-figure projects. So if you're spending a few $1,000s with the lawyer, again, not shilling for lawyers, but it gives you some peace of mind that things are going to go smoothly instead of finding out at the end, oops, my favorite word. Sometimes you say something worse than oops, but it turns out that, the assessment wasn't passed properly, or this wasn't done properly, or, whatever. And then you might have to do it all over again or ratify what you've done.
No.
So,
and again, Peter, it's important in what you said, and you could add that as a soft cost as well.
Right.
You're committed. So in essence, again, when you're looking at a multi-million-dollar project, it's very different than looking at the day-to-day operation. So absolutely work with you, and you have to add those soft costs anyway.
Right.
So just do it right the first time. Don't waste time, energy, because it does take a lot of professionalism from all parties to go ahead and really do it correctly.
Yeah, and those soft costs, she makes a great point. Maureen makes a great point. Things like legal fees, engineering fees, not so soft, but they're there. The other fees that are ancillary to the project, you want to include those.
Permitting.
Because they are real numbers and they are real costs. Okay, so my slide boy will do that. Okay, so the next thing or part of this is we talked about special assessments. Now I'm going to talk about borrowing, financing, particularly for these bigger projects. By the way, do you have to get a loan? No. Okay. It is helpful sometimes, particularly if you're owners, not everyone is wealthy, believe it or not. And these big projects, which result in 5-figure or even 6-figure assessments, because I've seen both, can be a real strain. So the borrow, just like when you're buying a house or buying a car, you can't put up that much cash in one time. You try to finance it through a loan or some kind of financing. So that is almost always a board decision whether to go with financing. Okay. You need to really check your documents here carefully. And again, we already mentioned this 10 times. I'm going to make it 11th time. This is really where you need counsel assistance when you're going to borrow money. In fact, the banks almost require it because of opinion borrower counsel. We'll get to that in a second. So check your documents. In my opinion, anyway, and this could be different with different lawyers, under general corporate law, corporations have the authority to borrow. Under most sets of documents, the association through the board is granted the powers of under Chapter 718, which is the Condominium Act, and Chapter 617, which is the Not-for-Profit Corporation Act. But there are still many documents out there, and I mean many, that say you need owner approval to borrow money. Okay. If you need owner approval, you have to get the owner approval. Unlike the other thing I was talking about before, where you don't need owner approval to actually do a maintenance or repair project, okay, that doesn't apply to this, in our opinion, or my opinion. If you need to borrow money and your documents do have an owner approval requirement, and you have to look through all the documents, by the way, sometimes it's buried somewhere, like could be in a declaration, could be in the articles of incorporation, could be in the bylaws. You need to scour through and see if there's any owner approval requirement. So this is, again, where counsel can be very, very helpful to that. Meeting notice, unlike the special assessment, to approve a loan is a 48-hour notice requirement. If you want to do more, that's fine. If you're somehow combining that with your special assessment meeting, obviously that's a 14-day notice. If anything that's involved with the special assessment, you need the 14-day notice. But when you're approving a loan, okay, you want to make sure that you're specifying the amount, the lender, who you're getting the money from, your interest rate, your repayment terms. Is it a 7-year loan? Is it a 10-year loan? What's the interest? Those kind of things. Is it a line of credit? Is it revolving? Is it this? Is it that? So make sure that you got what the loan terms are, the nature of what the project is. Is it concrete? Is it roof? Is it whatever it might be? That is in your meeting minutes as well. And what Maureen was just mentioning before, when you're doing your special assessment, you got to incorporate your costs. Okay. So there's the project costs, interest costs, attorney fee costs, engineering costs, all these things, and probably a cushion too, especially if a concrete. Unfortunately, not that I'm here to talk about concrete restoration, but it is linked to this, unfortunately. Frequently those projects are over the initial estimate, and not because the engineer stinks or the lawyer's a bum or all that kind of stuff. It's just the nature inherent in the work. It's tough to nail those down. So I would always recommend you put a cushion into your special assessment. Still might not be enough, but whatever percentage, I'm not sure what Maureen recommends to her people or the engineer recommends, anywhere from, I would say low is 10% up to more like, even 30% as a cushion. And you may have to do another special assessment if it really gets, but anyway, just realize that you try to, match your special assessment to the project. You also want to give yourself some lead time as far as collecting your special assessment money, because the contractor needs to be paid, the bank needs to be paid. So you don't want to have it so tight that you're waking up, you're not sleeping at night wondering, gee, are enough owners going to pay so we can pay our bills next month. So give yourself some lead time on you have to coordinate, in essence, when your cash flow with your outflow, right? So
Yep.
you want to make sure that you're bringing in enough money, even if it's a little extra, to make sure that you're going to be able to meet those, because the contractor, he, she, it, they deserve to get paid. So engineer and all the other people, even us, even those.
Yeah, and Peter, and you mentioned again having your contingency, that percentage there, again, 10-20%. It's a rule of thumb. It's always best to have it, best practices, but obviously you need to learn how your association operates, learning how many people can actually pay, consider, forecasting those that may fall into the delinquency stage. Again, all these little things is where you partner with your management team, your owner's rep if it's a big concrete restoration engineer, and your legal team, and even your audit team, your auditor, your CPA. So all these experts come in together to do the best for the association. And these things, again, it could be a 48-hour 14 notice or whatnot, but at the end of the day, all of this legwork it's months of planning correctly to do it correctly.
Yeah, good point. Yeah, coordinate with your team, coordinate with your
Yep.
professionals. And look, stuff is still going to go south occasionally, but you try to do as best prep as you can. So getting into a loan, as far as the nitty-gritty with the loan documents, the closing documents, the first thing you're going to end up signing is a commitment letter with your lender. Okay, that's going to set forth the terms of the loan. It is a binding agreement. It is a contract in essence, and it will set forth typically interest rate, the term, the type of loan, what's required, like an opinion of counsel, this, that, and the other thing. It will also usually have the amount of the loan fee, if there is one. Typically there is. Sometimes it's a percentage. Also, typically you have to pay the borrower's counsel fees. The lender's counselor fees plus your borrower's counselor fees, but your lender counselor. So the commitment letter, relatively short document, but in bullet points, it will set forth the structure or the skeleton of the loan transaction. Promissory note. Well, that's the note that says, I promise to pay you X amount of dollars for X amount interest rate. And it says other stuff in there too, but the promissory note basically is your promise to pay back the bank, pay back the lender. You also want to make sure that, at least, and most loans have this, but you want to make sure there's no prepayment penalty in your loan. So if are the lucky enough to, maybe get owners to prepay some of their special assessments, or some pay in a lump sum and other pay over installments. We can talk about that in a few seconds. You can prepay, but you don't want to prepay with a penalty. So, and banks are, in my experience, are pretty good at not having prepayment penalties in their loan documents. So what is the collateral for this loan? Your firstborn? No. The collateral for the loan, unlike when you're buying a house or you're buying a building or you're doing a typical real estate transaction, it's not a mortgage. Okay, so you're not granting a security interest with your property or with respect to your property. So the bank is not getting a mortgage against the units or against the common area or against the common elements. What they are getting is an assignment, okay, a collateral assignment of your collection and lien rights. So what does that mean? That means that, God forbid, there is a default, okay, and it's pretty rare, to be honest. But if there is a default, the bank, in essence, can step into the shoes of the association to collect your assessments and to lien your units. So that's the collateral. And I've been doing this a long time. And back in the ancient days of the covered wagon, a lot of lenders, they would steer clear of associations. They were like, the associations was a very strange animal. They weren't used to them. They didn't want to loan to them. I think the first one, not that was a Banco Popular and a couple other banks a long time ago, realized, you know what? Association's a good borrower. Association's a great borrower. They don't go out of business. Typically, they have a steady stream of income through their assessments. And now a lot of banks, lenders are falling over themselves to get association business as far as loan or lending. But to go back to the collateral, so the collateral again is your assessments and your lien rights that if you default, they can step into the shoes. So what do you need as far as closing one of these transactions? Again, you're going to have your attorney, most likely, review the loan documents. Number one, because you want to make sure that there's nothing in there that's, egregious. And secondly, the bank is typically going to require it, especially for any big loan, because the bank's going to require an opinion of borrower's counsel, meaning us, that you had the authority to enter into the loan, that you've dotted I's and crossed T's in terms of your special assessment that you adopted. They're going to want to see the minutes of that meeting. They're going to see the meeting notices when you approve the loan, when you approve the special assessment, because most loans, there is a special, not every loan, okay, but most loans, especially the bigger ones, there's a special assessment associated with it. You're going to want to see the association's insurance documents to make sure you're up to date on that, a copy of your governing documents. Some of them want to see the contract with the contractor or with the engineer. And I'm going to go back to collateral for 1 second. One thing that I always look to in these loan documents, to be quite honest, the banks, look, they're stuck in their ways. They're much better with their loan documents now than they were years ago. But one thing I used to always have to raise, now they pretty much have it in there, is even though you're giving them a security interest in your assessments, there are certain things you need to exclude from that. For example, reserves other than the reserves that you're using for this project. You do not want to give them an interest as collateral in your other reserves, because like I said before, 4, 5, 10 slides ago, those are restricted, okay? So you don't want to give them a security interest in those other reserves or in other special assessment funds. Like it or not, you may have 2 special assessments going on at the same time, theoretically, one for one project, one for another project, or you may have something else come up during this project that you have to special assess for. You don't want to give them a collateral interest in special assessment funds that are assessed for another purpose. Okay, again, because those are restricted funds under the Condominium and Cooperative Act. You can only use those funds for that particular purpose. So you don't want to give a bank, and they understand this. In the old days, you had to kind of educate them, but they all understand this now, that the association cannot give as collateral assessments that are restricted for other purposes. The third thing I like to make sure is not collateralized is any insurance proceeds you may receive. God forbid we have a storm during this process, and now you're getting insurance proceeds, because under most of these loan documents, they want the bank wants to have collateral against everything that you have in terms of money. All of your funds, they want to have a secured interest in. But when I look at these documents, I exclude insurance proceeds, because those insurance proceeds under most documents in Florida law shall be used for the purpose for which they were paid, to restore the property, whatever was damaged. So I just want to mention that about collateral, that although you are giving them an interest in your assessments and your lien rights, it's not completely blanket. There are some exclusions, and the banks, are very willing to understand that. The bank councils now understand that. And most loan documents are written with that in mind, but you have to check it out. There's closing costs. You got to pay your lawyer. Typically, there are some other doc stamps and things like that, recording, origination fees. These closing costs are also costs you need to wrap into whatever your assessment scheme is, with your special assessment or through your reserves, or even through your operating budget. But realize these are also costs that are part of these projects. Okay. Q&A. So I know we're on Zoom, so it's not like I'm asking people to shout at me, but
and before we get to those, Peter, Maureen, can you see the Q&A? Do you want to take a look at those, and you can pose the questions to Peter? But before we do that, just a slight stray from what we normally do. We already put the link for the evaluation into the chat. Please click on that. That is required at this point, now that the course is over, for you to get your certificates and credits reported and certificates emailed. Normally, the slides are available instantly right after you fill out that evaluation, but this time we are going to email them to you with your certificate so that we can correct the error that Peter mentioned earlier. We want to make sure you have the proper version of the slide. So we'll make sure that, and Barry, that's noted too, thank you. Well, we want to make sure that all the corrections are there before you actually have the slides. So yeah, in the chat, if you haven't already enabled your chat, press the button so chat appears. We're going to place the link in there once again. Maureen and Peter, back to you guys.
Yes, and to add it, Jeff, because I know again, you and I have done this in the past, and thank you, Peter. Such a fun course. I love it. In case, obviously, your CEUs, just email us. Sometimes they go to spam. So just we're here for you to help. So, anyways, one of the questions, are these new laws for condos only or HOA too?
Pretty much
Regarding the
condos.
reserve
Yeah,
redesignation. I know you
that's
mentioned it lightly, but it's a refresher. Yeah.
that's okay. That's for condominiums and co-ops. Okay. All of that Champlain Tower stuff, I'm not speaking that lightly. I actually knew someone who died in that building, so it was horrible. But yeah, so the HOA reserve law changed a little bit, like I mentioned, but all that CERS and all the restrictions, that's for condos and cooperatives.
Perfect. So this is a in between question. How do we get owner's approval to receive notices electronically? Effort.
Ask.
Yes, effort.
Literally ask and make sure they send something in writing. Okay. They can revoke it. If they revoke it, then you also keep the revocation, and then you send them the old-fashioned hard copies. But it's pretty simple. I mean, I think your management can just send out, maybe if it's once a year, twice a year, quarterly, I don't know. Quarterly is probably more than you need to, and say, who wants to get, by the way, you don't have to do this. Okay. You can send out hard copies the old fashioned way if you want to, but in my experience in 2026, can't believe it's 2026. In 2026, this is a digital age, electronic age. Most people love to just do stuff digitally, which is fine. Just ask, and ye shall receive, and have them send it to you. And
Peter,
just,
and I think it's how you evolve, right? Because think about it. Several years ago, even the elections, right? And this is totally off, but again, it has to do with electronic. You know, you'll be in an election for 4 to 6, even 5 hours.
oh,
Like
the
right
electronic
now,
voting. Yeah.
right. So when you get into this whole electronic, everything easier. Obviously, you have to make sure your notices are correct. You have to make sure everything is done correct. It's just you're saving yourself association money at the end of the day because of the mailing portion of it. Also, the legal portion of it. You don't have an attorney, and your team till 5 6 hours in hosting a meeting.
I mean, you make a great point, because even though we're not talking about that, I'll just,
I know.
since you mentioned it, I don't have that many clients that do the electronic voting still, but the ones I do have love it. They
Yes.
absolutely love it. Just because, just as you said, the counting instantaneous. You're not sitting there for hours with people throwing paper airplanes at each other or other things. Yeah, they love it. The ones that have the electronic voting, love it. Now there's even email voting. I'm not going to get into that. It's new.
Yeah.
It's a little
A little
confusing.
bit more complicated.
Yeah, it's a little complicated, it's a little confusing. I'm kind of sad that they did it actually. But yeah.
Yeah.
So yeah, the electronic age is here, and take advantage of it.
Yep. Yep. And here's another good one. In reference to
Okay.
your statement, as far as a unit owner approval and a board decision, which falls into safety? Does your statement apply? This project is maintenance strongly in need. So
Yeah, I mean,
it's
yeah,
commercial.
safety would be part of that. I mean, at the end of the day, if in doubt, get the vote. But, or get an opinion of your engineer, okay, that this work is necessary. Don't just leave it up to, Betty board member, Joey board member. Oh yeah, this is necessary. Okay. Some things obviously are no-brainers, but otherwise, get an opinion of an engineer that the work you're contemplating, if there's an issue about needing owner approval or not, get an opinion of an engineer that what you're doing is necessary for the maintenance, repair, protection of the building, property, or the owners, and you should be in pretty good stead. Again, not including loan approval. Loan approval is a separate thing. If it says owner approval, you need owner approval. The only time you wouldn't need owner approval for something like that, and I guess I should mention this, if it's an emergency and it's a hurricane situation and the governor has issued that your area is under the hurricane emergency edict, then you can borrow money actually without owner approval. That's an exception. Okay.
Well,
Um,
it happened in Hurricane Irma, if I'm not mistaken.
yep.
Yep.
So that's a limited exception. Okay.
Mm-hmm.
Other than that, yeah, you need to be, again, if in doubt, vote or get an engineer's opinion.
Yep. And the legal, always with all the
Yeah,
voting
these kind of
notices,
things you should go to
please.
council on
A
again.
100%.
Um,
Yes, Peter, here's the one that links basically the same concept. If a parking lot has a broken concrete, could it represents obviously a hazard safety? Does the repair for that excess of 100K be a board decision or require resident vote?
it's almost always a board decision.
100% with you. But
Almost
again,
every
double
time.
check with your legal counsel. But it just links with the same information
Yeah.
that Dominic
Anything
asked.
that you need to do to maintain that property, in our opinion, is a board decision. Imagine if you went to the owners and they said no because they're too either ignorant, cheap, combination. And then
Mhm.
what? You're going to have a hazardous situation or a building that might fall down, especially in the post-Champlain environment that we're in right now. You
Yep,
really cannot kick the can down the road in terms of necessary repairs, in my view.
yep. Here's one. We set aside funds from monthly maintenance to pay our annual insurance premium invoice. Can this fund be excluded from collateral assignment? Oh, this is an interesting one.
I don't, the assessment, the amount to pay the premium for your insurance,
Right,
my
excluded.
opinion would be no.
Yeah,
Okay. Um, I think that just like any other, I realize it's insurance and insurance is important. Um, it's an interest. I haven't had that question before.
that's why I
My
said it's an interesting
my
one.
opinion would be no. Okay, I think the insurance proceeds themselves are excluded. I don't think that the assessment for the premium cost is excluded from the collateral.
Yeah. What should a condo association do if they may not have the ending reserve balance on a CERS they submitted to the state in 2024? Hmm.
I think they're going to need to increase their assessments to make sure that they're on track.
Yes.
Okay.
And we again, best practices. This is not and correct me if I'm wrong, Peter, because you're the counsel here. I've been often asked the reserves, when should we update it? Should we do it yearly, every 3 years, every 5 years? So I know how that has changed through time, but just
Well,
tapping into a little bit about that, the reserve
okay.
study.
Well, the only one that's mandated right now is the CERS, and
Mm-hmm.
that's every 10 years. But that's the minimum. You can definitely do it more often if you want. There
Yeah.
currently is no requirement for the non-CERS, but I would definitely encourage you to do it. In my view, 7 years is a good time period. I think 10's a little long, quite frankly. I think five
Yep.
to seven is better because stuff changes.
Yep.
Costs change. Uh, these are all guesstimates anyway. I mean, none of us have I always make a joke to my clients that my crystal ball is broken. And it is broken. So I don't know, what we say today, is that going to be the same 5 years from now, 7 years from now? So again, the minimum for a CERS is 10, but you can do it more frequently. No requirement right now for non-CERS reserves, but I would suggest 5 to 7 years is probably a good time frame to have that study done.
Yeah. And Peter, you mentioned a saying, what was it nickel pound fully? I
Oh,
don't know the saying.
penny wise, pound foolish.
There you go. So again, if you're going now, we're starting budget season, right? A couple of weeks from now, we're like on the go for budget season. To update a reserve study, it's not, it's something that's worth it.
Right.
It's worth it. So if you could do
It's
it,
worth a
have
few
that
thousand
happen.
dollars, I think,
It's a few,
right.
right?
It's worth a few $1,000s. It's not like it's $100,000. Um,
Exactly.
so again, to be accurate for the protection of your property and your owners, again, it's your money, not my money, so it's easy for me to say that. I get it. I just think it's a prudent decision.
Yep. Yeah, best practices again, but
Yep.
that's when you consider it in your operating budget. If the reserves are not allocated yet to any project and you are about to do a major repairs that may need a loan or a special assessment, does the condominium apply the reserve toward these new projects?
Well, I'm not sure how you have an unallocated reserve. It's kind of a contradiction in terms.
Yeah.
Reserves by their nature are restricted to something. Okay. If you
Mhm.
have some type of, I guess, general reserve account, and some associations do, I guess they vote to waive the statutory reserves and they have some sort of general unallocated reserve, assuming, check with your counsel, but assuming you've jumped through hoops to create that, I think that could be applied to almost anything. Okay. Depends on your reserve budget, the wording, how you came about to have this, I guess, quote, general, unquote, reserve. If you do have such a reserve and you've done it correctly, I think that could be used for just about anything.
Yep,
But
yep.
check with your counsel on that one and make sure you're not spending reserve funds improperly.
Yes, no commingling, please. So, John, this is a good one. Hopefully it happens, but we're in the business and normally it doesn't. But anyway, in a situation where special assessment is required and we add a cushion of XYZ, in the happy event where we don't
Surplus,
use all the money, what is the typical practice to handle the excess of funds?
you mail it to Maureen and she buys a new oceanfront place like she's got there in the background. You have two choices with surplus special assessment funds. You can either return it to the owners, which I've never seen, or you apply it as a credit to a future assessment. And that can either be a budget or a special assessment. So let's say for that happy occasion that, you assessed 500,000 and the job came in at 400,000 for whatever reason. You have $100,000 in surplus. That can be applied as a credit to the next budget or to your next special assessment project. So if your next special assessment project is 200,000, you apply the 100,000 as a credit, and now it's 100,000. That is a more typical way that I've seen. Rather than writing checks back to the owners, almost invariably it's applied as a credit toward another assessment.
And think about it, it's an expense also writing all the checks. So if you
Right.
have a condominium that's 700 units, that there is going to be an expense mailing out and all that stuff. So yes, you have to work practically
Yeah.
and
I'm not saying that you can't or you shouldn't, but I just think
right.
in my experience,
Be wise.
it's usually applied as a credit.
Yes, yes, I've seen that as well. So Derek says, we recently issued a special assessment and we were told we could not add any extra money. You suggested have a 20% buffer contingency. And if we have to inform the residents of all associated with the assessment, how will we add a buffer? I mean, you already
Well, you can
passed the special
always add a
assessment.
buffer, okay? I mean, you're saying basically when you adopt a special assessment, there is no rule, there's no requirement that it has to be exact to the penny of what the estimated cost of the project was. I'm not saying you should assess triple the amount of the project. I'm just saying though, just because of the way life is, oftentimes there just are cost overruns. And I think it's fine to include a reasonable contingency in that assessment. And if you do have some maybe extra operating funds, you can throw those in there too. Remember, the operating funds can be used for anything. Operating funds are not restricted, unlike reserves. And if for some reason the special assessment falls short, you might have to do another special assessment to, supplement it. Hopefully not, but it does happen. But I mean, long story short, I know no legal prohibition against adding a reasonable cushion or contingency to your. In fact, many operating accounts have unallocated cushions in them, as they should, because your operating costs don't come in on the nickel normally. So your estimated budget is $1 million for the year. I think most associations will probably, and Maureen will probably agree, will operate their budget a little bit higher. Okay, not double, but a little higher. Again, because even on the operating side, stuff happens and things are maybe more expensive than you guessed, that they would be.
Correct. So
So we have time for one more.
yes, yes. So if I understand correctly, COAs must have three bank accounts: operating, regular reserves, and SERS.
Well, three, yeah. I mean, they can, yes, they have to
It's
have
a key bucket.
three accounts on paper where they keep track of the money separately. Yeah. I mean, if you're going to commingle operating and reserves, then on paper, though, you have to have separate account records of how much is in the reserve, and your account can never go below what the reserves must be. All right. Um, it's probably best, yeah, to create the three physical accounts if you want. It's easy, probably easier that way. But yes, there are operating, reserve, and special assessment. Those are all separate in essence of what they're used for.
Yes.
Okay.
That's it.
Well,
Excellent
that
job to
was
you
good.
both. Thank you.
Maureen, it was lovely seeing you.
Yeah. Peter, fun.
It was good. So I
I
hope it
love
was
the
educational.
education.
Education good, as my father always said. So
Yes, thank you very much. I really enjoyed co-hosting this with you, Peter and Jeff. Thank you very much. There's a great questions to ask. Obviously, we could continue the conversation. Thank
good.
you.
Thank everyone for attending. Thank you.
Well, thank you both.
Thank
You both
you.
have a wonderful day. And
Thanks, Jeff.
Peter, take care. Maureen, always great to see you as well. Keep on smiling. Very inspirational. Thank you. And it's hard to, you're in this business a long time. It's not easy to smile. There's often a target on all of our backs. So just remember, folks, never to take these things personally. People are usually upset with an idea or a concept, and it's not us. So do the best you can to remember that. I know Maureen does. Have a great day,
Absolutely.
everybody.
Have a great day,
Thank you very
everybody.
much for allowing
Take
us
Bye-bye.
to be of service.
Bye
Bye-bye.
bye.